Act was amended with effect from the 1st of April 2019. And a key part of those amendments was to essentially expand our audit mandate to go beyond auditing and reporting. And it was really about finding ways for us to strengthen accountability in the public sector. The amendments are intended to act as a complementary mechanism in the broader public sector accountability value chain, and they do so by strengthening financial and performance management. These amendments introduced the concept of a material irregularity. A material irregularity means any non-compliance with or contravention of legislation, any fraud, theft, or even breach of fiduciary duty which we identify through our audits. And we have to look at this and consider whether such non-compliance is likely to result in a material financial loss, result in the misuse or loss of a material public resource, or cause substantial harm to a public sector institution or even to the general public. We identify MIs to support accounting officers and accounting authorities by bringing to their attention the irregularities that could have a significant impact on finances, on resources, on service delivery, while also empowering them to take timely action, appropriate action as required in terms of legislation. The Act, read together with the MI regulations that have been gazetted, those are shaped to support the fair process, transparent process, and to ensure that all that we do is legally sound and consistent with the principles of fair administrative action. They provide an opportunity for the accounting officer and the accounting authority to take actions that are required to deal with the material irregularities. Where they don't act, we, as the auditors, refer the material irregularity to a public body. We then, following that investigation, can make recommendations that seek to resolve the MI that is sitting in the audit report. If they fail to implement the recommendation, then we can take binding remedial action for the failure to implement our recommendations. And if that doesn't work, then we can issue a certificate of debt in the name of the accounting officer or accounting authority that is responsible for failing to take action to stem financial loss or to stem harm to institutions or the public. When we identify an MI, the accounting officer or the accounting authority is notified, and we do this without delay, and we give them 20 working days within which to respond. We then, following their response, we assess it and check whether or not it meets the legislated requirements, and we allow for the implementation, and then we follow up on their progress on implementation. If they don't implement as required, then we follow the steps until we are satisfied that they do that which is prescribed in law. An MI is fully resolved if the losses that were incurred are recovered, or when the further losses that may have been incurred are then stemmed, and also when the key actions that have to be taken against people who either underperformed or did wrong are actually taken to their logical conclusion. This may even include reporting matters to the law enforcement agencies. We are determined to follow the letter and the spirit of the law to ensure accountability